Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hello and welcome back to the Business Law, Estate Planning, and Estate Podcast with attorney Thomas LaPorte. Tom is the founder of LaPorte Law Group, PLLC, with offices in Portsmouth, New Hampshire, and Andover, Massachusetts. With more than 30 years of experience, he helps individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. I'm Lisa Mosbey, your host, and today we're talking about powers of attorney, healthcare directives, and how these documents determine who can make financial and medical decisions if you're unable to act for yourself. Welcome, Tom. Thank you so much for joining me again.
Thank you, Lisa. How are you doing?
I'm doing well. Tom, how do powers of attorney fit into the overall structure of an estate plan in New Hampshire and Massachusetts?
All right. Well, when people hear estate planning, they tend to think, at least I've heard this from many people, many clients, they tend to think of their wills. They tend to think of trusts. So instruments or documents that are relevant when someone passes away. So an estate plan should include documents that are operative when we're alive. So powers of attorney, healthcare proxies are also called durable powers of attorney for healthcare in New Hampshire. Massachusetts, they call them healthcare proxies, as well as the federal form, the HIPAA authorization form. All are documents that one should have, couples should have for use during their lifetimes. In the event that one or both of them become incapacitated either temporarily or on a permanent basis. So, like a will or a trust, you appoint someone to act in your stead for things that we do when we're alive in the event that we're not able to do so.
And Tom, I know families often assume a spouse or an adult child can automatically make decisions if something happens. What actually determines who has authority to act in a medical or financial emergency?
That's a good point. And similarly, um, with children that are adult children, 18 years or older, parents will just assume, well, I'm the parent. I should be able to find out if they're in hospital, for instance, what's wrong with them. Well, that's not the case anymore. Maybe back in the 1800s out west, where people knew everybody, that would be the case. But um, even if one is married, spouses are married to each other, if, for instance, the husband becomes incapacitated, he is in some sort of accident where he's unconscious. Well, banks, particularly, and other institutions will not share information with the spouse just because she is married to that incapacitated person or husband. And it works vice versa as well. Medical institutions, hospitals, particularly with the advent of HIPAA, the sixth section of which became effective in 1996, took them 10 years to create this law. It's gargantuan. They are very protective of private healthcare information. So that's the case even with family members. So in today's modern age, you need to have three instruments that appoint your spouse or another trusted person to not prepare financial documents, but to transact business, such as paying bills, making deposits. Those are your financial and business items. And then, of course, to make healthcare decisions for you in accord with your wishes would have been. And all of that is indicated in advance with these three documents.
And financial powers of attorney can be written in different ways. What are the key distinctions families should understand when deciding how broad or limited that power should be?
Good question. There is a durable power. It's called a general durable power of attorney. And how that operates, and with my clientele, if the clients are in a committed relationship with each other, whether they're married or in some other sort of committed, trusted relationship, well, then most of them will choose the general durable power of attorney. That is different from the second option, which is called the springing durable power of attorney. With a general durable power of attorney, it's like our Fifth Amendment. It's all around us. It's effective at all times, and we just have to invoke the Fifth Amendment to remain silent. In this case, Lisa, if we're married and you are my attorney, in fact, under a general durable power of attorney, you then use your discretion when I'm incapacitated to take care of my business, pay my bills. If we need to sell a house and you need my signature, I just happen to be in an accident. Well, you'll sign, and you can sign for me as um, my attorney, in fact, under my general durable power of attorney. In situations where the attorney, in fact, and that's the agent, that's the name of the agent under a durable power of attorney, where the attorney, in fact, is perhaps not related by blood or not in a such close committed relationship, whether it's a third party, not a family member, trusted, but not that close. A springing power of attorney is not general, it's not in effect at all times. What happens there is that a treating physician, as well as another consulting physician, say I've got cancer, I'm using myself as the incapacitated person. Well, my treating physician and a consulting oncologist have to certify in writing that I'm incapacitated. Then that power of attorney springs into effect, and that friend of mine who's the attorney in fact can now act on my behalf. Those are the two main differences with the durable power of attorney.
Yeah, and Tom, healthcare directives and living wills each serve a different purpose. Can you explain the difference between those two documents?
Yes, I practice in 3 states. I'm licensed in 4, but for the eastern states, Maine, New Hampshire, and Massachusetts. Massachusetts and Maine are quite similar, and New Hampshire is slightly different. A healthcare proxy, that's the name in Massachusetts, or the durable power of attorney for healthcare in New Hampshire are they give power in advance to your agent, your healthcare agent. That's the name of the agent with regard to those documents, to carry out decisions that I have already made in advance. Another name for these documents is called an advance directive, because in advance, using myself as an example, I have indicated what care I want to have um, given to me in the event of my incapacity. Um, with the living will, a living will has to do with those situations that involve end of life. And there are 2 types. One is near death with no reasonable chance of recovery. And the other one is I may be near death or not, but there's no chance of my recovery, which is usually seen in a coma type situation. And if using myself again as the disabled person or incapacitated person, I should say, if I come out of the coma, then I'm not going to be uh, go back to the quality of life that I had. We've all read about the vegetative state, the Karen N. Quinlans, the Terry Shibos of the world. In those types of situations, the living will deals with the medical provider, the hospital most often, in providing extraordinary measures. And in the living will, I say in those situations what I want to have done. And the choices usually are do everything you can to keep me alive. Transfusions, defibrillation, dialysis, intubation. Those are all extraordinary heroic measures that cost a lot of money, but some people believe in the sanctity of life, no matter what its form, and they would so choose. Or the other, another example on the sort of opposite end of the spectrum would be, listen, I don't want to be a burden on my family. Keep me comfortable. Um, Give me pain medication, which usually means morphine. And if you've started those types of heroic measures, stop them. And if you haven't, don't start them. And then, of course, both states or all states allow you to sort of make a middling decision. I just had a client say, well, look, take a week, do what you can for a week. And if after a week, there's been no improvement, then stop. Um, In Massachusetts, the living will is regarded as guidance only. So it's more of a government knows better sort of state. It just is. And they will give the doctors a little bit more power over those decisions. Whereas New Hampshire, it's not treated as guidance and it's more strictly followed under the law in New Hampshire. So hopefully that answers your question.
It does. And I'm trying to tie all of these pieces together because there's so many documents involved when we're doing this type of planning. And I know that banks and financial institutions sometimes hesitate when they see an older power of attorney. What are some of the issues that come up when these documents haven't been updated in years?
That's a very good practical observation. In real life, that's true. Um, Years ago, I can't tell you when, but there is a uniform law. When you hear of a uniform law, the 50 states have generally adopted this uniform law. Some states modify the uniform law, some accept it as it is, and there is a uniform law with regard to durable powers of attorney and these other instruments that we're talking. Well, really, the healthcare proxy, not so much the HIPAA document. That's fairly new.
Yeah.
But if they see an old document, particularly banks and lending institutions, which happen to be one of the more or most conservative institutions on the planet, and you have to understand why, especially lately with all the bank fraud that's going on. They're very, very concerned about protecting their depositors' deposits. Because oftentimes the banks end up paying for losses due to fraud. So if they see an old durable power of attorney, and by old I mean 5, certainly 10 years old, they are oftentimes going to be very reluctant to honor it, and you may need to have something done fairly quickly, and it will take days to provide the entire document, provide identification, to check the signatures. And then the other thing they do is if they don't see the verb or gerund, I guess it would be called. I'm thinking my 8th grade English class. If they don't see the word banking, they may say, well, it doesn't say banking. I've seen this. So I put banking in my powers for the attorney fact to have, not just carry out all financial transactions. I think it's subsumed in that, but um, banks now require their own verb, banking. So those are a couple of reasons that you want to keep your powers of attorney up to date.
That makes sense. And then when two or more people are named to make decisions, what situations tend to come up with families that may think about drafting these documents?
Well, when you have two people, um, that inherently creates a potential conflict because two people, even siblings, the closest of siblings, if you've got two adult children who are your attorneys, in fact, or your healthcare agents, particularly over health, okay, because there's more emotions involved with a person's health, a parent's health, a grandparent's health. So if you have two people named, then there's a possibility of conflict, of disagreement, and delay. Um, Same thing, by the way, with the springing power of attorney. Doctors can disagree too. Um, but lots of people choose two people. I haven't seen three. Well, actually, I have seen three, um, because they want to check and balance. And there's a feeling that still exists that we want to give everyone a role. We don't want to offend um, uh, our daughter Mary because Jim and Joe, our sons, are either an executor or a trustee or attorney in fact or healthcare agent. We want Mira to have a role too. So conflict potential is a problem. However, it's sometimes chosen not only to give recognition to a family member, but also as a check and balance against the other. So that would be a positive reason. So when you choose two people, the bottom line is in almost every situation is that you got to choose people that will get along, respect each other's opinion. They may discuss something, but ultimately they will come to a consensus.
And then, Tom, with long term care planning, it often intersects with medical decisions. How do these documents support families who are navigating health challenges or maybe care transition?
Yeah, they are needed because if care transition, that's a good way to put it. People that are going into assisted living or they are moving into a nursing home situation, um, they really must have ready for them to bring with them their healthcare advance directive with the living will provision, as well as the HIPAA authorization, which I don't think we talked about too much, but we can. Uh, Otherwise, a lot of these institutions have their own forms, and I have actually seen at the bottom of these institutions forms a release of liability. Absolutely not. You should never sign someone else's form, um, a release of liability, and it's binding because it's presumed that we read it and understood it. If we're of the age of majority without a diagnosed or court recognized cognitive disability.
And you mentioned HIPAA forms. Why are those important to have signed ahead of time?
They're important because the federal government and, federal governments and state governments often do redundant things. Um, and the federal government decided, especially with the advent of the internet and information is being transmitted electronically, um, that another document was needed, and that's called a HIPAA authorization or HIPAA representation form. And all that means, and it's a one-page document, but it is important because the hospitals are looking for them. If in the event that, say, Lisa, you're in the hospital, incapacitated or not, and you've got 3 children, uh, young adults perhaps, well, the hospital is not going to tell them anything about your situation, how you're doing, what your health status is without a HIPAA authorization where your 2 or 3 adult children that I created uh, uh, are named in the HIPAA authorization. So hospitals and other medical type providers, naturopaths, um, even physical therapy outfits will not release any information about how you're doing, where you are. So it makes sense to have that as well because if your attorney and your healthcare agent is supposed to carry out your decisions, he or she is your champion. Then if he or she can't get information or they can't get information, then how are they going to make an informed decision? So you need to have both.
And Tom, we're going to wrap this up with a little inspiration from you. And that is for someone listening who hasn't reviewed their powers of attorney or healthcare directives in a really long time, what steps can help make sure that these documents reflect their current wishes and circumstances?
Well, thank you for the opportunity, particularly for those that have documents that have not been looked at in 5 years, certainly 10 years, and you're not alone. If they want to call and run some inquiries by me, uh, or they can access, contact me through my website. I have a little scheduling program where people can talk to me for 15 minutes, and it doesn't cost them anything. It gives them some clarity. Um, and that's on my website, which is laportelawgroup.net, N-E-T, and my phone number's on there as well, and they can go from there.
Perfect. Thank you so much for your time today, your guidance. We always appreciate that. And that's it for today's episode of the Business Law, Estate Planning, and Probate Podcast. Thank you so much for listening. And please remember to subscribe, like, and share this episode if you know of somebody who might need it. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.